The defendant was in jail and found the weapon. It was a plastic toothbrush where the end was filed down to a sharpened point. Brown admitted to making a shiv for protection. He also on video was seen making a fist and practiced punching with that weapon in his hand. Logan Brown was being transported to the ER for stomach pains. Brown attempted to escape from the hospital and had to be subdued. A handcuff case was broken and 2 law enforcement officers suffered bruising from landing on their back hip area where the handcuff was located.
So I would run my sentence in 7115 consecutive to those imposed in 7114 and 7116. I would commit Mr. Brown into the Michigan Department of Corrections for a term of...
That homemade shiv and the chaotic hospital escape you just watched in the preview, they look exactly like the actions of a highly dangerous criminal. But the reality behind this judge's impending sentence is far more disturbing. This is the state versus 22-year-old Logan Brown. It looks like a clear-cut case of escalating inmate violence, but it's really about a deeply vulnerable mind pushed entirely to the breaking point. Prosecutor Goodich calls Logan a remorseless mastermind who boldly drove a stolen car across state lines. Yet, his family insists he doesn't even possess the basic motor skills to drive down his own street. Is his blank courtroom stare cold defiance or severe autism spectrum paralysis? At stake is up to 10 consecutive years in state prison. If you want to understand courtroom psychology and how justice actually operates, hit subscribe. Let's see how this unfolded.
Good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And I also just wanted to put quickly on the record that just before we came out, I'm sure everybody saw the prosecuting attorney came through from the door that leads to chambers. And the prosecutor was accessing the courtroom through there, and I detained her to talk about some matters that are totally unrelated to this case, which is entirely proper and often happens. I just wanted, given that timeline, to let you know I wasn't back there talking with the prosecutor about this case. All right, we're here for People v. Logan Brown for a sentencing that was continued from Tuesday. It's filed 25-7114, 7115, 7116, and 26-7145. Counsel, you want to state your appearances beginning with People?
Melissa Goodrich for the People.
No, and I am Mr. Brown, who appears in person in custody to my right.
All right. And we have sentencing in 7114 for larceny in a building, a 4-year felony with 0 to 11 guidelines range. 7115, possession of a weapon in the jail, 5-year max with a 10 to 23 month range. 7116, a felony larceny, 5-year max with a 5 to 23 month range. And 7145, an assault of a jail employee, again a 5-year max and a guideline range of 12 to 24 months. I have reviewed the pre-sentence report as well as the clinical assessment of needs memorandum from the mitigation, like a mitigation specialist, as well as request for restitution from the People. All right, Mr. Nightingale, have you had a chance to review these materials with your client?
I have, Your Honor.
Do you have any additions or corrections to them?
Yes, I think that probably both parties want to make some sentencing guidelines challenges. I would, and I know there are 4 different cases here, so try to see that I go in order and that I don't go too fast. But the guidelines as it relates to 7114 do appear to be correct. To me, no challenges there. As to 7115, I have PRB 6, which is currently scored at 15 there. I would argue that it should be scored at 10, just on a strict reading of the way that 15 is written, but in jail awaiting adjudication or sentencing on a conviction or a probation violation. He's not obviously here for a probation violation. At the time that this offense was committed, he was not in jail awaiting adjudication on a conviction, if that makes sense. He was on some sort of bond status awaiting adjudication or sentencing for a felony. So I would argue that should be scored at 10 rather than 15.
All right, Ms. Goodrich, your response?
I believe he did plead to all 4 files at the same time, so I would agree that it'd be 10.
Well, what is in jail awaiting adjudication on a conviction mean? Adjudication is the plea. It says adjudication or sentencing.
Yes, so, and I will acknowledge that this is a very technical reading of the way this sentencing guideline is written. But I would posit that in jail awaiting adjudication or sentencing on a conviction would not be the applicable wording here, because at the time that Mr. Brown possessed the weapon in the jail, he was still on bond. He had not pled guilty or been awaiting sentencing. He clearly wasn't here for a probation violation. And so, you can be on bond in jail, just your bond hasn't posted. And so I think the 10 would be more appropriate.
Well, I'm not sure I've had anybody raise that question. The wording of that is not ideal.
Correct.
Sure. I do see 10 points for someone being on bond awaiting adjudication or sentencing for a felony. The difference between that and the additional 5 points for 15 points is that they're in jail awaiting adjudication or sentencing. It says on a conviction. So the one difference is whether they're on bond or in the jail. But here, he wouldn't have even been on bond because he was in the jail. So the 10 points wouldn't score. He wasn't on bond awaiting that adjudication. He was in the jail. There was no bond. So it seems to me that the guidelines are trying to make a distinction between somebody who's on bond committing a crime and in jail committing a crime. And when you're incarcerated in jail and nonetheless are still committing criminal behavior, that's arguably worse behavior because you're in a controlled environment, yet you're so persistent in your criminal activity that you're going to commit crimes even there. And the distinction between a felony or a conviction would mean that 10 points would score if you're on bond awaiting adjudication for a felony, even if that felony was later dismissed or you were adjudicated not guilty. But in 15, there has to be that felony has to result in a conviction, which it has here. So here there is a conviction for the crime that he was awaiting adjudication for. That's such a strange way that's worded. I think to read it as the defense would argue is perhaps a strained reading that would actually result, I think, in 10 wouldn't fit, or because he wasn't on bond, and 0 wouldn't fit. He didn't have no relation to the criminal justice system. His relation to the criminal justice system was he was in jail. So I think I'll leave PRV 6 scored at 15 points.
Thank you.
All right. Your next objection?
As to 7145, would make the same objection as to PRV 6, just for the record, understanding what the court's ruling is going to be.
Okay, and I'd make the same ruling, and that objection is preserved in 7145 as well.
Thank you. And then as to offense variable 10 in 7145, apologies, he's got obviously a ton of cases here, so we'll go through them one at a time. So as to OB9, which is 7145 under the public safety, this scored at 10, and this is for the case where he was taken to the hospital and then essentially ran out the front door of the hospital I would argue that, fewer than 2 victims were placed in danger of physical health, injury, or death. I believe that there was only 1 deputy on the scene, and somebody can please correct me if I'm wrong, but at least to my knowledge, there was only 1 deputy that was actually, chasing Mr. Brown out those doors. Only 1 deputy that was injured as a result of that. And so I think that should be properly scored at 0 rather than at 10.
Your Honor, I believe it says that under the facts of 7141, that Deputy Klatsky had heard the radio traffic about the escape, and he assisted with helping Deputy Smith secure Brown and standing him back up.
Well, I guess the defense is saying, the sentence before that says, upon Deputy Kalatsky's arrival at the hospital parking lot, Deputy Smith had Brown subdued. And then Deputy Kalatsky assists with securing Brown and standing him back up. I don't know exactly what that means, but perhaps, securing the handcuffs or whatnot. But by the time, if I understand Mr. Nightingale's argument, by the time Deputy Kalatsky arrived, Mr. Brown had been subdued. And if he's in the status of being subdued, he was no longer presenting a risk of harm. Inside, they removed some medical equipment from him. I suppose, it would be easy for me to imagine that during this assaultive episode at a hospital, that some of the other staff may have been placed at risk of harm, but I don't have enough information in that pre-sentence report to make that factual finding by a preponderance of the evidence. So based upon that, unless Ms. Goodrich, you wanted to have an opportunity to supplement that record, absent that, I would sustain that objection and score OB9 at 10 points or at 0 points. That brings the total OB to 30 instead of 40. Next on the Class E grid. That does bring it down from level 4 to level 3. And that range then, instead of 12 to 24, it'd be 10 to 23. Is that right, Mr. Nightingale?
That is what I have, yes.
Did you have any other scoring challenges, Mr. Nightingale?
No, Your Honor, thank you.
Ms. Goodrich, did you have any scoring challenges?
I do, Your Honor. First, as to 7114, I believe that OB19 instead of 0 should be scored at 25 points because his behavior in the jail while on bond for the larceny in the building.
Okay, so obviously that's scored in the in 7115, the possession of a weapon in the jail. And your argument is that because OB19 is not a McGraw factor and we are not limited to the circumstances of the sentencing offense, we can look at what happened after the sentencing offense.
Correct.
That his behavior in the sentencing offense of 7115 is therefore properly scorable under OB19 in 7114. Do I understand you right about that?
Yes.
Mr. Nightingale, what's your response to that?
Thank you, Judge. So I'm just going to rely on the plain language of OB19 and say that, within, and I recognize the people's argument and what the court has said about the McGraw factors, but that, there's no conduct within his 2 cases, the larceny in the building and then the larceny between $1,000 and $20,000 that would indicate any sort of threat to security of a penal institution or interference with administration of justice or rendering emergency services as the offense variable dictates. I do think that obviously they're properly scored under his cases in which he was in jail. But that there's nothing particularly about those cases that would indicate any sort of threat to security.
Okay, and the case law has for years consistently interpreted OB-19 as allowing the court to consider circumstances after the elements of the sentencing offense are completed. For example, if somebody fails to appear for court, they're going to get 10 points under OB-19. If the police go to arrest them on a warrant for the sentencing offense and they resist that arrest, even if they're not charged with that R&O, they're going to get points under OB-19. And in similar fashion, if they're in the jail and threatening the security of that penal institution or court, then that's 25 points. So I think the prosecutor's objection is well taken. I would sustain that. And I would score in file 7114 OB-19 at 25 points, which brings the OB level from 1 to 26. This is on the G grid. Did you have other objections in 7114?
I do not.
Okay, so that's on the G grid. Oh, that would bring it from 1 to 3. And instead of 0 to 11, it would be 2 to 17?
Yes.
Okay. And I take it then from Mr. Nightingale's comments that you had the same objection, Ms. Goodrich, as to 7116,
Yes.
the
I did
larceny?
notify him ahead of time with my objection.
Okay.
And she did.
Okay, because after the larceny, there was the conduct of the assault of the jail employee. Is that correct?
Yes.
Well, here's my question though, as to that one specifically, although it was an assault of a jail employee, it didn't happen in the penal institution. It happened at the hospital.
Well, he's in custody.
While he's in custody, that is correct. But the language of OB-19 is is that the offender by his or her conduct threatened the security of a penal institution. I don't know that I would score it that way. I don't know that the assault at the hospital during an attempted escape from custody threatened the security of the jail. It was, however, a use of force or threat of force to attempt to interfere with the administration of justice. So I would score OB-19 in file 7116, the larceny, at 15 points, which raises that OB from 5 to 20. On the Class E grid, I would bring that to from level 1 to level 2. So rather than 5 to 23, it would be 7 to 23. Is that correct?
Yes.
Mr. Nightingale, I presume that my ruling has perhaps triggered a new challenge by you as to the 25 points that were scored in OB-19 in file 7145 for the assault case itself. But because it didn't happen in the penal institution itself, 25 points wouldn't be appropriate.
Yes.
Would you agree with that then?
I do.
Based upon my ruling about those facts, I think the OB-19 in 7145 for the actual assault, because it didn't threaten the security of the jail itself, but was the use of force or threatened force to interfere with the administration of justice or attempt to do so, I would score that at 15 points. So that reduces it another 10 points. So we're at, instead of 30 points, now we're at 20 points. And on Class E, that brings us from 3 to 2. So again, instead of 10 to 23, we're now at 7 to 23. Is that correct? All right. Any other challenges from either side?
No.
All right. What I have then, just so we're clear, on 7114, I've changed OB 19 from 0 to 25. That's increased the range from 0 to 11 to 2 to 17. In file 7115, the range was unchanged at 10 to 23. No objections were taken. In 7114, I granted the prosecutor's objection and scored OB 19 at 15 points, or I granted it in part and scored OB 19 at 15 points, which increased the range from 5 to 23 to 7 to 23. And in file 7145, I granted a defense objection and changed OB 9 from 10 to 0. And I granted a defense objection on OB 19 to change it from 25 to 15. And that changed the range from 12 to 24 months down to 7 to 23 months. Any further challenges or objections to my math? Mr. Nightingale?
No.
Ms. Goodrich?
No.
All right. Do one more mathy thing here. Okay. Okay, Mr. Nightingale, anything you want to say on behalf of your client?
Yes, Your Honor, thank you. So Mr. Brown comes before the court at 23 years of age. He has been in custody now since August of last year. As you know, the memo filed with the courts regarding his clinical needs assessment outlines, I think, much better than I'm probably about to outline. You know, Mr. Brown suffers from a wide range of mental health issues. You know, not just you know, it's what I would call his actual mental health issues. You know, the facts that he does sometimes have episodes of psychosis. You know, he does sometimes hear and see things that are not present. You know, he also has autism spectrum disorder. You know, he's got at least has been diagnosed with a learning disability. You know, did not go very far in school. Struggles with daily tasks. This is, you know, in my opinion, one of the most complicated types of clients that I have, because you know, when, in my opinion, obviously, when Mr. Brown gets the type of services and skills training that I think that he could absorb, right? You know, I think that he could be a functioning member of society. You know, I think that once he has his proper mental health diagnosis, once he is properly medicated, once he has not sat in a cell essentially by himself for almost a year, only listening to his own thoughts and trying to decide what's real and what's not. I think at that point, you know, he's going to be able to move forward and potentially, you know, get a job or at least get himself on some sort of a disability regimen and continue to move forward in a productive fashion that does not involve him being in orange or God forbid being in blue. I just think that you know, the Michigan Department of Corrections, I'm sure, would at least attempt to assist him in receiving those services as part of any sort of prison commitment. However, it would certainly be our perspective that you know, a Department of Corrections sentence would be just so detrimental to Logan's ability to move forward in his life. You know, he is probably not going to be able to get into the services that he needs at the Department of Corrections based on some of these convictions that he's getting as a part of these cases. You know, they were probably going to class him higher than maybe I would argue that he should be classed because of these. And, you know, from many perspectives, right, I understand why that would occur. You know, they're going to have legitimate concerns about him. The jails have legitimate concerns about him. But he's just one of these folks who is not going to do well in a jail or a prison sentence or a setting. He is not going to be spoken to in the manner in which he is going to be receptive to those communications. It's only going to increase his paranoia, his inability to access these services and to access the appropriate medication that he needs when he's not even had a legitimate diagnosis, at least not recently. Judge, further, you know, the autism spectrum disorder puts like a whole nother layer on how complicated dealing with Mr. Brown has been. And, you know, I think in the PSI, there are some indications that Mr. Brown is, you know, not cooperative, not remorseful. I think part of that is, you know, I always tell my clients, you know, the time to make a statement about your cases is in front of the judge. It's not in front of the probation officer, because God forbid something happens and we need to withdraw the plea or something, you know, I don't want those statements in that document, right? So I think maybe his lack of statements were in some ways misconstrued as a lack of remorse. What I would further posit to the court is that, you know, this, at least the two cases, the larceny cases, both involve his brother Noah Marshai. You know, I think it's clear from what's in the PSI that, you know, Mr. Marshai obviously tried to scapegoat Mr. Brown in some of the actions that Mr. Marshai was directly involved in and were Mr. Marshai's ideas. Mr. Brown is unable to drive a car. In speaking to his mom and his mom's partner, you know, they are both adamant. There's absolutely no way that Logan could have driven that car. I mean, he can't even drive down the street, let alone the 10th seat. And so he would have been in the passenger seat. He would have been following his brother. He would have been naive enough to do these things. And he has accepted responsibility for what he's done. I mean, he's here having pled guilty to a series of felonies that could, of course, subject him to a prison term here. He's not here asking or telling the court, well, it's all Noah's fault. He's pled guilty and he's here responsible for what he's been responsible for. But I do think the court should know that, you know, his gullibility, his naivete is what really brought him into that situation in the first place.
Well, I mean, I could infer that from the fact that no leader points under OB-14 were scored as well.
Correct. And so there's just no universe in which that was Logan's idea, but of course he went along with it. And I think part of that is, you know, his autism spectrum disorder. Part of that is, you know, he just doesn't have the skills and resources to know when people are leading him astray. You know, part of that happens over time, right? Part of that, you know, he's going to need services to develop those sorts of skills. When I spoke to his mom on Tuesday, our plan was to try to get him into some sort of a group home. I think that's still an option for him if the court were to not give him a prison sentence today. You know, I think that he would literally leave right now and go get a mental health assessment and try to get on medications, because he has not felt good for many months. Not just physically, but certainly mentally. And he recognizes that. You know, Logan doesn't talk a lot. He's not a chatty guy. He doesn't present in the same way that people who are not neurodivergent present. And sometimes those presentations are misconstrued. I believe as he sits here today, probably maybe the court would infer that he just doesn't care, but that's not true. This is just part of his autism. And so I would ask the court to acknowledge that, to acknowledge the difficulties he's going to go forward in the world with, to acknowledge that, you know, if he is sentenced to prison, the likelihood of him getting any better from this point, I don't want to say never, right? Because people make their own choices, and he will not be in prison if that's the sentence forever, right? He's going to get released. It just is going to set him back so far. And so I'm asking the court, I know that the agreement is to sentence him within the guidelines. And so the court is limited in some respects to what the court can actually do today with the amount of cases, with the mandatory consecutive nature of some of them. However, I would ask the court to fashion his credit time in such a manner that the court could potentially time serve him today, let him go home with his parents, let him go get a mental health assessment, get these medications that he so desperately needs. And, you know, anything else that the court thinks would be an appropriate service, I think Mr. Brown would do and wants to do. So that's what we're asking for today. Thank you, Judge.
Thank you, Mr. Minka. Mr. Brown, you don't have to tell me anything today, and if you choose not to, I don't hold that against you, but you are also welcome to tell me anything you want today. Is there anything you want to tell me or no?
Oh, right now I really don't got right now I ain't really got much to say other than that I should do my time like a man because I did commit the crimes. But that's all I got to say.
All right, thank you. Ms. Federici, the recommendations from the people?
Yes, Your Honor, thank you. We are here because on file 7114 on May 17th of 2025, the victim called and reported his nephews, Noah Marshai and Logan Brown, who stole a PS4 from his tenant, posted it for sale on Facebook. Logan Brown was interviewed and said he had memory issues from drug use, but that he was with Michael Lounsbury and they stole the PS4. And Noah Marshai found out and told Brown to return it. In file 7116 on May 18th of 2025, the victim's car was stolen, later found in Tennessee. The investigation determined that Noah Marshai and Logan Brown, who are brothers, stole the vehicle and drove it to Tennessee, both accusing the other of being the driver. On August 12th of 2025, Logan Brown posted bond. On August 16th, his family requested that the bond they posted be revoked and he was taken back into custody and has remained in jail since that date. In file 7115 on September 1st of 2025, the defendant was in jail and found with a weapon. It was a plastic toothbrush where the end was filed down to a sharpened point. Brown admitted to making a shiv for protection. He also on video was seen making a fist and practiced punching with that weapon in his hand. In file 7145 on January 30th of 2026, Logan Brown was being transported to the ER for stomach pains. Brown attempted to escape from the hospital and had to be subdued. A handcuff case was broken and 2 law enforcement officers suffered bruising from landing on their back hip area where the handcuff was located. Logan Brown is 22 years old. He has 4 cases today. He has no prior felonies, but 5 misdemeanors. He's unemployed with a 9th grade education. In the PSI, his mom had reported alcohol dependence as well as mental health issues. It was also indicated in the PSI that defendant appeared to have no remorse or accountability for his convictions. He also refused to complete the compass assessment. I did receive today the mitigation memo clinical assessment. It really didn't address anything or talk about anything that Logan Brown had done in those 4 cases, failed to recognize any of those behaviors. I think sometimes these lose credibility because they always recommend 0 jail time. I think there'd be more credibility if sometimes they're like, hey, in this case, I do think that some incarceration is appropriate, but it's always 0. So I don't think there's anything new in this memo. The recommendations that were given can all be addressed in a prison sentence. The plea here was any incarceration within the Michigan sentencing guidelines. There was 1 on-charge case in exchange for Mr. Brown to pay the restitution. In file 7114, kind of going in chronological order of when they occurred, the PS4 was returned, so there's no restitution being asked in that case. The guideline range after objections are 2 to 17. The PSI recommends time served. I agree with the PSI for time served in that case. In file 7116, the guideline range is 7 to 23. I would ask that restitution be ordered joint and several with Noah Marshai in the amount of $1,350. The PSI is recommending time served the 217 days. I'm in agreement with that recommendation. Next file is 7115. The guideline range is 10 to 23. The PSI recommends 10 months jail with 0 credit. We are asking that that weapon be forfeited. And I'm also asking that top of the guidelines be ordered 23 months with 0 credit. I believe that addresses the goals of deterrence for having weapons in our county jail. It sends a message to law enforcement that their safety is important, as well as other inmates, that that activity will not be tolerated. Also, I would ask for a deterrent effect for Mr. Brown committing one felony after another. We have 4 here in a short amount of time. That repetitive crimes or crime sprees will not be tolerated. It also addresses the sentencing goal of punishment, especially given the no remorse or accountability for his actions, which I believe would result in the likelihood of reoffending and a low likelihood of rehabilitation that probation could address. In the last case was his attempted escape from the jail. The guidelines are 7 to 23. The PSI recommendation is 12 months with 0 credit. He is escaping, creating a chase situation in a hospital environment that caused public safety risks, not only to law enforcement, but to the public around them, the hospital employees. I would ask the court to address the sentencing goal of deterrence to escaping while in custody of law enforcement. He was on bond when he did this for 3 other felony cases. There are reasons to exceed the guideline range. However, because of the plea agreement, he received that benefit in the negotiations. He also received the benefit of not having the final case, the MDOP, charged. Instead, he was just asked to pay the restitution. I would ask that to be ordered in the amount of $1,783. Thank you.
Thank you. Mr. Brown, if you please stand for the court sentence. Well, Mr. Brown is 22 years old with no prior felonies. He does have a misdemeanor record. And there's a bond violation in 7114 for a fight with his stepdad. I'm just going to go ahead and dismiss that at this point. I think that doesn't serve anything. And also, I'm going to add 3 days jail credit in 7114 and 7116 because we adjourned it from Tuesday. In this case, there was a multiple offender situation, and I recognize that Mr. Brown was not like a clear leader in that situation. So that's, that accounts for the 0 points in OB 14. He does have a prior assaultive history. The defense argument that, his lack of remorse, may have been mistaken just for his lack of making statements. I would think that's not likely to be true. The agent that completed the investigation and report is a seasoned agent. I won't call him old, but he's a seasoned agent and he's seen a lot of things. And, I see a lot of these reports where the defendant chooses not to make a statement, and there is not a similar notation that they are failing to show remorse. It's their right not to make a statement, and that's never really held against them. But it's all sorts of other indicators that an experienced probation agent would see in interviewing somebody and completing that investigation that would cause that. So, I would defer to that experience. I think that wasn't just a mistake. Also, I can't really do a time served here for all of these. The defense argument is based upon some of Mr. Brown's mental health issues, that then being in jail or prison is an environment that's only going to make those worse. It's only going to make his opposition worse, and it's going to make his behavior worse. And Mr. Nightingale made I think an eloquent argument about making that point. But I'm also concerned to say that, somebody in front of us might be too dangerous to manage in the jail. So I'm supposed to tell the people of Sheboygan County, best of luck. I'm going to send them out amongst you right now. That's a tough thing to do to the people of the town. The jail can't manage this guy, but I expect you to. So I don't think I can do that either. In any event, trying to balance all these factors, in file 7114 for larceny in a building, with a 4-year maximum, 2 to 17 months advisory guidelines. Going to assess $68 in state cost, $130 in a crime victims assessment, $350 in court costs, and a $60 fee, and must comply with DNA testing, in order that Mr. Brown serve 309 days in the Sheboygan County Jail with credit for 309 days previously served. That is a sentence within the advisory guidelines and also consistent with the plea agreement. In file 7116, the larceny, 5-year maximum, 7 to 23 guidelines range. In that case, there's $68 in state cost, $130 in the crime victims assessment. Now, order that Mr. Brown serve 220 days in jail with credit for 220 days previously served. Oh, and did I say restitution of $1,350 as requested? No objection being taken. That sentence is also within the advisory guidelines and consistent with the plea agreement. So those sentences in 7114 and 7116 are basically fines and costs, restitution, and time served. Then we come to 7115. That's where he possessed a weapon in the jail, sharpening the toothbrush down to a shiv and practicing an assault with it. My position for conduct of that nature committed while in jail on a felony for a sentence that Mr. Brown has now become liable to serve, that being the larceny building and the larceny, that would trigger MCL 768.7A1, that it'd be mandatory consecutive. I am aware that there are at least two, to my knowledge, there are 2 unpublished Court of Appeals cases that would restrict that statute only to sentenced offenders and not pretrial detainees. I believe those panels are incorrect in the interpretation of that statute because it ignores the phrase that the sentence for the new crime will begin to run at the expiration of the term or terms of imprisonment which the person is serving or has become liable to serve. To say it only applies to pretrial detainees, I think would read that language or has become liable to serve out of the statute. I'm required by my oath to apply the law. The statute is binding law. Unpublished opinions of the Court of Appeals are not. Therefore, I believe that this is mandatory consecutive. To the extent that I'm wrong, the statute clearly would apply for discretionary consecutive sentencing for committing a felony while another felony is pending, that being MCL 768.7B. For the reasons that the prosecutor stated about the need to protect personnel and inmates. I don't know who he was planning to assault with that toothbrush. Maybe it was another inmate. But the need to keep all those folks in the jail, inmates and staff, safe, and to deter people in the jail from sharpening things and fashioning weapons, I think that would call for the exercise of discretionary consecutive sentencing to the extent that mandatory consecutive is, to the extent I'm wrong about that. So I would run my sentence in 7115 consecutive to those imposed in 7114 and 7116. And I would also order $68 in state cost, $130 in the crime victims assessment, and order any weapon that was seized would be forfeited. And the guidelines at 10 to 23 months, taking into account the danger that Mr. Brown presented to jail staff and other inmates, but also I think that does call for a prison commitment, but also his lack of prior felonies, his youth, his relative youth, and his mental health issues, I think would call for something not at the top end of those guidelines. I would I would find that a midpoint sentence would be proportionate to the circumstances of the offense and the offender. And I would commit Mr. Brown in 7115 to the Michigan Department of Corrections for a term of not less than 16 months nor more than 5 years. And that's with credit for 0 days served because I'm running it consecutive to 7114 and 7116. Then in file 7145, Subsequent to those events, during an attempt to escape from jail custody, he assaulted jail staff. Again, he was in, although it didn't occur in the jail, he was in an incarcerated position while he's out of the jail in the custody of the jail staff for a hospital evaluation. So I do also believe that the mandatory consecutive of 768.7A is triggered. To the extent that it's not, for the reasons listed for the prosecutor about, protection of not just the officers, but now the hospital staff and the community. Just to the extent that mandatory consecutive does not apply, the court would exercise its discretion under 768.7B to impose discretionary consecutive sentencing for that offense. And also for the reason that it was the second felony crime that he committed while he was in the jail. And so in that case, there's $68 in state costs and $130 in crime victims assessment. Again, taking into account his the danger that he presented, his prior assaultive history does call for a prison commitment, but his lack of prior felonies, his relative youth, and his mental health issues call for something less than the top end of those guidelines. I would find again that a midpoint sentence would be proportionate to the circumstances of the offense and the offender. And at 7 to 23 months, by my math, that would be 15 months as a midpoint. So in 7145, I would commit Mr. Brown to the Michigan Department of Corrections for a term of not less than 15 months nor more than 5 years. Again, with credit for 0 days served. And this file will run consecutive to 7115, to 7114, 7116, and 7115. So what that means, Mr. Brown, is you're going to do 16 months on 7115 plus 15 months on 7145 before you are eligible for parole. So your eligibility for parole will be 31 months from now. And the maximum they can keep you if you continue to misbehave in prison would be up to 10 years. All right, those are the sentences from the court. Mr. Brown, if you wanted to appeal, you may do so by filing an application. If you want a lawyer, I'd give you one. You have to ask me within 6 months. So we're going to hand you a bunch of paper right now because you got 4 cases. It's 2 copies in each case. We're going to ask you to initial 1 copy in each file. So we have a record we gave it to you. And the other one's for you to fill out if you do want to take an appeal. Do you have any questions for me, Mr. Brown?
Sure.
Okay, good luck to you.
The judge made the final call. Logan was sentenced to 31 months behind bars. But did the system actually get this right? Comment below Team Logan or Team State. Was this sentence necessary for public safety, or did they just criminally punish a severe mental illness? If this verdict got you thinking, hit like. Share this case with anyone fascinated by the reality of true crime.